All right, everyone get ready. Because today, we are going deep into a legal case that just might make your head spin.
Oh, this is going to be good.
Yeah, we're talking about a patent application. But get this, it wasn't the kind that ends with everyone celebrating and popping champagne.
Oh.
This one got hit with a big fat rejection.
A patent that got denied. Now that is interesting. I'm intrigued.
Yeah, and this is going to highlight how hard it can be to get a patent.
Especially in biotech, right?
Exactly, especially in biotech.
Yeah.
So this invention was supposed to be like a total game changer. A live vaccine for livestock using a modified version of Salmonella bacteria.
Salmonella, huh?
You'd think that would be a guaranteed patent, right?
Sounds like it, yeah.
But, well, that's where things go a bit sideways.
Yeah.
The big players in this whole saga are the Regents of the University of California. We'll just call them UC. They're the ones who came up with this vaccine tech. And on the other side, we've got the controller of patents.
Which is basically the Indian Patent Office, right?
Exactly. They're the ones who basically said no to UC's patent dreams.
Yeah.
And this whole thing got so heated that it went all the way to the High Court of Delhi.
Wow, all the way to the High Court.
Yeah, and to make things even juicier, the court sided with the controller.
Really?
Yeah, leaving UC empty-handed. So let's break this whole legal roller coaster down. What was it about UC's invention that made them think they deserved a patent?
Well, they were working with what's called a recombinant version of Salmonella, a genetically modified version. And the really important part here is they put in these loss-of-function mutations into the bacteria's genes.
Lots of function mutations. Okay, you're going to have to explain that one because you've lost me a little.
All right, so imagine you've got a car, but you take out the engine.
Right.
It might still look like a car, but it's not going anywhere.
Right.
That's kind of what these mutations do. They basically break specific genes in the bacteria. In this case, it was a gene called DAM and at least one other gene, so they can't function properly.
So they're basically making the Salmonella weaker to make it safer.
Yeah, exactly. The idea was to use this weakened bacteria in a live vaccine, And UC was trying to patent both the modified bacteria and the vaccine that used it.
Makes sense. Weaken the enemy, so to speak, and train the immune system. Pretty classic vaccine strategy.
Yeah.
But where did things start going wrong for UC?
Well, their first hurdle was Section 3C of the Indian Patents Act.
Oh.
Yeah, that section basically says you can't patent something that already exists in nature.
Ah, so it's like they were saying, hold on, you're trying to patent nature.
That's pretty much it. The controller's argument was that UC was trying to claim a broad concept of Salmonella with just a few mutations.
Right.
And some of these mutations, they could even happen naturally.
So even though UC engineered these mutations, they were saying nature could do it too, so no patent.
Basically, yeah. Did UC have a response to that? They did.
Oh, they fought back.
They argued that there was no novelty objection. That means their invention wasn't something just taken straight from nature.
Oh.
And they really emphasized that the specific mutations they made were engineered to completely shut down those targeted genes. Something nature doesn't necessarily do in the same way.
So it was, did you discover it or did you invent it kind of debate?
Exactly. But even if UC's Salmonella was unique enough, there was a whole other obstacle waiting for them.
Oh no, what else?
Section 10(4) of the Indian Patents Act. This one's about insufficient disclosure.
All right, time for a quick legal lesson. What does insufficient disclosure even mean when it comes to patents?
Think of it like you're baking a cake. You can't just say, here's a cake. You got to give a detailed recipe.
I see where you're going with this.
All the ingredients, all the steps, so anyone could bake that same cake.
Right, right.
Well, a patent application has to be enabling, meaning it has to have enough detail so that someone with the right expertise could actually make the invention.
So the controller was basically saying UC's recipe wasn't good enough, not detailed enough.
Exactly. Now, UC did give some examples, but they only shared how to make one type of mutation, a deletion, and only in one specific type of Salmonella called typhimurium.
Ah, so their patent claims were way broader than that, right? They wanted to cover more than just that one type.
That's the problem. Their claims included other types of mutations, like insertions and substitutions.
Okay.
And it covered 6 different Salmonella cerevars.
So they were saying, we want a patent for all these different cakes, but they only gave the recipe for, like, a basic vanilla cake.
That's a great way to put it. And the controller was basically saying, hold on, you can't claim all these fancy cakes without giving us the recipes.
I love that analogy. So they didn't explain how to make the invention across all the things they were claiming, right?
Exactly. It left too much guesswork for anyone else trying to reproduce it.
Did UC try to defend themselves on this?
Oh, they did. They said, look, we gave the basic idea. A skilled scientist could figure out the rest.
Okay.
And they pointed out that the base Salmonella strain is publicly available, so others could start from there.
That sounds reasonable to me. I'm not a scientist, though. What did the court say?
Well, the court said, hang on a second, it's not the basic Salmonella that's the issue here.
Ah, I see.
It's the modified one with those specific mutations, and that's not just lying around for anyone to grab.
So, because their description wasn't specific enough and they didn't give anyone this modified bacteria, they were breaking the rules.
You got it.
Yeah.
And to make matters worse, there was another section of the Patents Act that tripped them up.
Oh, come on, another one.
This is Section 10.5, and it's all about how clear and specific the patent claims have to be.
So, were their claims too vague? Were they trying to be sneaky?
The court seemed to think so. UC was saying their claims were perfectly clear because there were only 42 possible combinations of mutations.
42, they even did the math.
They did the math, but the court wasn't buying it.
What was wrong with their calculations then?
Well, the court said they were ignoring the different types of mutations, deletions, insertions, and substitutions. Each of those can be done in tons of ways.
Oh.
So there are way more than just 42 unique bacteria that could be made.
So it's like, nice try, but your math is off. Your claims are way too broad for what you actually explained.
Exactly. And this ties back to a big case in India, the Novartis case, which the court leaned on heavily for this decision.
The Novartis case. Now that sounds interesting. Tell me more about that one.
It set a really important precedent in India. Basically, you can't have claims in your patent that are wider than what you've actually shown how to do.
So you can't claim a big area without actually showing how to get around in it, right?
That's the gist. You can't just play legal games. You have to show how your invention actually works.
So UC was getting hit from all sides. Not only did they not meet these specific rules, they were also being accused of maybe even slowing down innovation by claiming too much. That's rough.
It really is. And to add another layer of complexity to this whole situation, there's also the tricky deposit requirement to consider.
A deposit requirement, what's that about?
Well, there's this part of the Patents Act, it's Proviso 2 of Section 10.4, that comes into play when you're dealing with biological material.
Okay.
Stuff that you can't fully describe in words and that isn't already available to the public. In those cases, you have to deposit a sample of that material with an international depository authority.
Ah, I see. So it's like saying, here's the actual thing, safely stored away so others can get to it if they need to.
Exactly. But didn't UC argue that the basic Salmonella bacteria is already available?
They did, yeah. They said anyone could reproduce their invention using publicly available Salmonella plus the info they gave in the application.
Right. But the court made a key point.
What was that?
It wasn't the plain basic Salmonella that was the problem here. It was the modified strain, the one with those special mutations. And that wasn't something just anyone could get their hands on.
Ah, so because they weren't specific enough in their explanation and didn't deposit this modified bacteria, they were breaking the rules again.
Precisely. It's like saying, I've got this amazing cake recipe, but I'm not going to tell you the exact amounts or where to get that special ingredient, and oh, you can't have a slice of the cake either.
Not very convincing.
No, not at all. I can see why the court wasn't impressed.
Yeah, I'm starting to see why too. But this brings up a big question for me. What happens to these potentially helpful inventions that get caught up in these legal issues? Are they just lost forever?
That is a fantastic question, and it really gets to the heart of the matter. This case has some pretty big implications.
Oh, I bet. I can't wait to explore those. But first, let's take a quick pause and make sure everyone's up to speed on the legal terms we've covered so far.
Yeah, it's a tough balance to strike.
Right.
We want to encourage scientists and institutions to come up with these amazing innovations.
Right. Yeah.
Stuff that could save lives. But at the same time, we don't want to just hand out patents left and right.
Yeah.
Not if it means other people can't do research or if it makes important medicines harder to get.
Exactly. So how do we find that balance? Where do we draw the line?
This is where that sufficient disclosure thing we were talking about becomes so important.
Okay.
The Indian Patents Act is there to make sure that patents aren't just giving out for any old idea.
Right.
They have to be for inventions that are actually clearly explained and can be copied by other people in that field.
So it's not enough to just have a good idea. You got to be able to show others how to do it too.
Exactly. It's about making sure that everyone can benefit from these discoveries. In UC's case, with this vaccine, the court was worried that they didn't give enough details about those mutations and how to make them in different types of Salmonella.
Yeah.
And that could slow down research in the long run.
So instead of helping things move faster, their patent application might actually slow things down.
That's what the court was afraid of.
Wow.
It's like they were trying to claim a big chunk of scientific territory, but they didn't provide a good map for anyone else to follow.
So no landmarks, no directions, just here's a big area, you figure it out.
Yeah, something like that. And by doing that, they might have accidentally blocked other people from doing their own research in that same area.
It kind of makes me think of those patent trolls you hear about.
Oh, yeah.
Those companies that buy up a bunch of broad patents just so they can sue anyone who gets close.
Right, right.
Now, I'm not saying UC was trying to be a troll,
No.
but the court seemed worried about that kind of thing happening.
And that's why the Novartis case is so important.
Right.
It's a reminder that you can't just get away with vague or super broad claims.
Definitely not with something as important as medicines, right?
Exactly. And this whole debate about whether UC was trying to patent something that already exists in nature, that's really interesting to me.
Yeah, it is.
Where do we draw the line between discovery and invention, especially when we're dealing with the natural world?
Right. I mean, are we allowed to patent living things? It feels like a big philosophical question, not just a legal one.
It's a question people have been asking for ages. You know, philosophers, legal experts, they've been going back and forth on this forever. And now with all the advances in biotechnology and genetic engineering, it's even more complicated.
Yeah.
Section 3C of the Indian Patents Act, it's trying to deal with this exact issue.
Yeah.
It says you can have patents for inventions that use natural stuff, but you can't just patent something you found in nature.
So if I find a new plant in the Amazon, I can't just patent the plant.
Yeah.
But if I use that plant to make a new medicine, that's different.
Exactly. The key is whether humans did something to change it.
Okay.
Did they use their knowledge and skills to create something new and useful that wouldn't exist without them?
I see.
In the case of UC's vaccine, the court was trying to figure out if those mutations they made, those loss-of-function mutations, were really an invention or just a natural thing that they happened to discover.
So it's like the difference between seeing that lightning can start a fire and actually making a device that uses electricity to start fires whenever you want.
That's a great analogy.
One is just observing something natural. The other is using that knowledge to make something completely new.
Perfect. And it shows how important it is not just to innovate, but to show everyone how your invention is different from what already exists out there in nature.
So you got to prove that you actually added something new to the mix.
Right. And in UC's case, the court wasn't convinced that their modified Salmonella was special enough for a patent.
Okay, so where does that leave us? What does all this mean for other biotech inventions, especially in India? Are we going to see fewer patents now because of this strict interpretation of the law?
It's hard to say for sure, but what this case definitely tells us is that the Indian Patent Office and the courts, they're really paying attention to these kinds of applications.
Yeah.
They're setting a high standard, both for how new the invention is and for how well it's explained so others can copy it.
So it's like they're saying, don't just throw a bunch of fancy science words at us and expect us to approve it. Show us the proof. Show us it actually works.
Right. They want the data, the examples, the clear explanations, the whole 9 yards. This might mean more work for inventors,
Yeah.
but it could also lead to stronger patents that actually help drive innovation.
So it's a wake-up call for the biotech industry. You want to play in this field, you got to be ready to do your homework.
I agree. And that's not necessarily a bad thing, right?
Well,
it could push the industry to be more innovative and maybe even encourage more collaboration.
Yeah.
You know, where patents are used to share knowledge, not to block other people.
so what's the big takeaway for our listeners today? What should they be thinking about?
I think the key message is that things can get really tricky when law and science meet, especially in biotechnology where it can be hard to tell what's a discovery and what's an invention.
Yeah.
It's super important to be careful, be transparent, and really focus on making something truly new.
Don't try to do too much. Make sure everything's clear and accurate, and focus on pushing science forward.
That's good advice for anyone, really, not just scientists and lawyers.
Absolutely. But hold on, everyone. We're not quite done yet. There's one more piece to this whole puzzle. UC tried to use decisions from other patent offices to try and convince the Indian court.
Ah, yes, this is where it gets really interesting. The world of international patent law, it's a wild ride.
It sounds like UC was trying to pull the, hey, everyone else loves our invention, why are you being so difficult
Yeah.
card. But did it work? Let's find out after a quick break.
We're back and ready to tackle the last piece of this patent puzzle. So UC tried to use the fact that they already had patents for this Salmonella vaccine in Europe and the US to sway the Indian court.
It's like they were saying, see, everyone else thinks it's great. What's your problem?
Right. Like if it's good enough for those patent offices, it should be good enough for India.
Well, it's a common tactic, especially with these complex biotech inventions.
Yeah.
Companies often apply for patents in lots of different countries to try and protect their work globally.
Makes sense.
UC probably thought those European and US patents would give them an advantage in India. Yeah, I mean, on the surface, it seems logical.
It does, but here's the thing. Patent laws aren't the same everywhere.
Aha, right, of course.
What might be patentable in one country might not be in another.
So it's not just countries being difficult or trying to protect their own companies.
No, not necessarily. Each country has its own laws, and those laws reflect their own values and priorities.
So there's no such thing as a universal patent.
Yeah.
You can't just get one and expect it to work everywhere.
Exactly. And the Indian court made that very clear in their decision. They basically said, look, we respect those other patent offices, but what they decide doesn't control what we do here.
Okay.
This invention has to meet our standards, our legal requirements to get a patent in India.
That makes sense. It's like you can't use your driver's license from one country to drive in another country that has completely different traffic laws.
Exactly. Just because you pass a driving test in one place doesn't mean you automatically know how to drive everywhere else.
Right, right.
Well, UC didn't really do their homework on the specific rules of the road in India, so to speak.
Ah, good analogy.
They tripped up on those requirements for sufficient disclosure and clear claims, and those other patents they had didn't change that.
So did UC's attempt to use those international patents backfire then?
You could say that. It might have even reinforced the court's opinion that UC wasn't really taking India's patent rules seriously.
Interesting.
It came across as a little, I don't know, arrogant, like they were saying, well, everyone else let us get away with this, so you should too.
Yeah, it's not going to win you any favors in court.
Not at all. So what's the lesson here for inventors and companies working globally? Should they even bother applying for patents in multiple countries if the laws are so different?
It seems like it'd be a lot of work for nothing.
No, definitely not. It's still really important to protect your inventions globally,
Okay.
especially in today's world where everything's so connected. But this case shows how crucial it is to understand the specific patent laws of each country you're targeting.
So you can't just translate your patent application. You have to tailor it to each country.
Exactly. It's not about finding one universal patent. It's more like learning how to speak the patent language of each country.
Like becoming multilingual, but for patent law.
Exactly. You need to understand the little differences in each legal system, the criteria for getting a patent, and the potential pitfalls to avoid.
And that means having good patent lawyers who know the local laws.
Absolutely essential. It might sound like a lot of work,
It does.
but the payoff is huge, you know? Having strong patent protection in multiple markets, that's worth the effort.
I can see that.
And it's not just about protecting your own invention either.
No.
It's about contributing to a global system of innovation where the rules are clear, fair, and help everyone move forward.
Well said. I think we've uncovered some really fascinating insights into the world of patent law today, especially with all the developments in biotechnology. It's amazing how these simple ideas like invention and disclosure can get so complicated when we're talking about living things and genetic engineering.
And we've seen how getting patents in multiple countries can be a smart strategy, but only if you're willing to play by the rules of each individual country. No cutting corners.
This case with the Salmonella vaccine, it's a big reminder that patent law is not one size fits all.
Definitely not.
It's a complex and constantly changing field, and it requires careful planning, a deep understanding of the rules, and a lot of respect for how each legal system works.
It's a reminder that innovation works best when we have clear rules, but also when we're open to adapting and learning from each other.
So to all our listeners out there, keep exploring, keep asking those tough questions, and keep pushing the boundaries of innovation.
But before you dive headfirst into the world of patents, make sure you've got a good legal map and compass to guide you.
Yeah, couldn't have said it better myself.
Yeah.
Until next time, keep diving deep.